All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is number 2020-0529, Florida Bar versus Crowley.
May it please the court, I'm Scott Tozian, and I'm here with my client and co-counsel, Chris Crowley, in this case. We're here primarily today to ask the court to find that Rule 4-8.2a of the Rules of Professional Conduct is facially unconstitutional in its intent discrimination and based on the cases that we cited in our brief, beginning with the New York Times versus Sullivan. And we don't dispute that the bar can ban defamation, but it has to be done under proper circumstances. And the cases that we cited all talk about a subjective recklessness burden to show that the speaker knew or should have, did know, or was reckless in its disregard for the probability that the speech was false. And the cases we've cited, again, starting with the New York Times versus Sullivan, in that case, they talked about how important speech that deals with public debate is under the First Amendment, and that it's a core subject for First Amendment speech. And in the New York Times, they said that the public issues should be uninhibited, robust, and wide open, and they may include vehement, caustic, sometimes unpleasant attacks on government and public officials. And that's what we have here. We have somebody running for state attorney and was the chief assistant.
Would you concede that if the election were a judicial election, you'd have a harder argument to make here?
There's no question about that. I mean, the Canon 7 of the Code of Judicial Conduct doesn't allow any type of repartee between the...
And would you further concede that, or would you argue, I guess is the right word, that if this were an election for state representative, you'd have an easier case? Or do you think that your election for state attorney is equivalent to a congressional or a state House race in terms of the constitutional issues that attach?
I hadn't thought of it in those terms. I think it's definitely... There's definitely much more protection, First Amendment protection, in a state attorney race because the state attorney
than in a judicial race.
Yes, without any question.
But there is, I think, an acknowledgement in our jurisprudence on this, not at the U.S. Supreme Court, and we're sort of now far afield of New York Times versus Sullivan. But if we start talking about what we've done, both in Ray and in other cases, we've privileged the legal offices like state attorney because they are officers of the court in a special way, because the impartial administration of justice by a state attorney is a compelling, I think. Would you concede that that's a compelling interest for First Amendment purposes?
No,
you don't.
We do not. No.
Okay,
absolutely not. And the reason we don't is because the state attorney is a public figure, and under the reasoning of the New York Times case, those people have...
But so are judges, right?
I'm sorry?
But so are judges, right? Judges are public figures.
They are, but I would submit to you that judges' impartiality is more important than a state attorney.
Really?
I think it's a fact. I think it's a reality that they are more impartial than the state attorney.
Let's dissect that a little bit.
Okay.
Yes, I would agree with you that the job of a litigant, a litigator, is to make arguments for one side. But that's not the relevant definition of impartiality. The relevant definition of impartiality is the prosecutor going to prosecute crimes by friends and foes alike? And that, I think, is a pretty core concept. Wouldn't you agree?
Yeah, it absolutely is a core concept.
So then how is that not a compelling interest?
Because when the state attorney, at least in my circuit runs, they talk about law and order, law and order, law and order, and it sounds much like it's pro-prosecution and pro-law enforcement. I mean, that's the platform that they use to run. And so I don't.
Well, they are prosecution.
Well, that's true. And I know that they're bound to do justice, not just to get people found guilty.
To sort of use the facts of this case, the concern would be that, for example, a prosecutor a candidate who makes statements about his opponent being associated with the PLO or being a proponent of Sharia law, one might see, if one were a voter of certain religious backgrounds, that cuts one way or another. In the same way that if a judge had made those statements, a litigant of certain religious backgrounds might say, I'm not going to get a fair shake from the prosecutor, from the judge. I guess that's my point, is that to me, that is the question on which you're looking for impartiality. And the reason I care is because if it is the same compelling interest, then I can use the line of precedent that tells me, okay, now we're talking about, is it narrowly tailored? Now we're talking about, is the bar rule narrowly tailored? Where I think you have a better argument.
It's partisan political speech. I think that's the key to what you're deciding here today. This judicial speech isn't partisan. They're muzzled. Anybody that's run for office as a trial judge knows that. You can't say anything. And as a prosecutor, you can campaign, and the public needs to know. And that's another problem with suppressing speech in these types of elections, is the public needs to know what the qualifications of the two people are, and the second person that's running, the opponent, has every ability to do exactly the same thing, and that is, give a counter argument to what's been said about them. In this case, Mr. Crowley never said that she was a Palestinian or that she was a Muslim or that her religion was in any particular way. He posted a very small part of an article, and that was conflated into him. Why
don't we focus on the conviction rate for a minute? So the statement is clearly false, that her conviction rate is 39%, right? You can see that that's a false statement.
I don't think it was ever shown to be false. I think that there were issues raised about it, that the percentage included the fact that there were a certain number of withholds of adjudication. In certain cases, it started in 2016, didn't finish in that year. So there were issues raised as to the validity of that, but I don't think it was proven that it was false. And what
did the referee find?
I think the key factor here is we're entitled.
What did the referee find?
Well, she found that it wasn't accurate for sure. I mean, I read part of the report again this morning. There was a lot to read.
Are you asking us to revisit that factual finding?
I'm sorry?
Are you asking us to revisit that factual finding?
Not so much that as to impose the recklessness standard before deciding that there's a violation of the First Amendment. That was not done. Clearly was not done. And one of the things, the referee found a lot of things, which in our brief you'll know that there was a lot of contrary evidence that she didn't accept. And I know that's what judges do. They accept this or they accept that. But it was across the board accepting what Ms. Fox and the people who testified on her behalf said, including the idea that she was not involved in the arrest and prosecution of Mr. Crowley, which strains credulity. If I was running for state attorney and my boss decided to prosecute my opponent and didn't confer with me, that would be shocking to me. And he also, when he did that, he said to FDLE, please expedite this. So, the referee found against us. There's no doubt. She didn't employ the proper test to all of the evidence. And we had the additional issue of her campaign treasurer being the same campaign treasurer who worked for Amira Fox. And when you take that fact, as what wasn't disclosed, we found out after the hearing, and you look at the fact that on every disputed issue of fact, we lost. She didn't acknowledge, for instance, that a witness testified that Amira Fox was campaigning on state time. Amira Fox admitted she had to return $1,500 to the state for taking excessive leave time. There was no comment on that, and potentially that would indicate corruption. So if you impose the recklessness standard against what was said, you come to the conclusion that it wasn't reckless. It was not with disregard as to the truth or falsity of what was said. Okay, moving on. I mean, that's the core of our argument, that we're entitled to the New York Times standard established in Garrison, established again in Counterman more recently, the recklessness standard, because there's never been a case in Florida like this. It's partisan political speech involving a lawyer's license. This is a case of first impression in the state of Florida. And there's nothing, I mean, I know many cases have said there's no distinction between regular political campaigns and judicial campaigns, for instance, although we know that there is a distinction. And in this case, it's a state attorney race, which is totally, it's totally different.
Counsel, if this were a situation in which the person was misleading the public, recklessly, intentionally, under that standard, not necessarily about their opponent, but about a factual issue in a political campaign, but just misrepresenting, we could say a fact or a theory or whatever, would that violate the bar rules if they're an attorney and they're misleading the public? They're making statements that are being quoted in the newspaper. They're being interviewed on a radio show. And
those statements are false?
I would say a reckless disregard for whether they're true or false.
If you employ the standard under New York Times and it was found to be reckless with no regard for the truth or falsity, I mean, I think we'd lose on that count. But
what about misleading?
Misleading? I don't think so, because I think that the whole idea of the First Amendment giving breathing space to political speech, it's got to be something that's pretty, I think, pretty severe. Otherwise, the First Amendment doesn't mean anything. Talk about the SLAPP statute, which was not employed in this case, and 768 has no prohibition against Florida bar matters being excluded from that, and it specifically was promulgated to protect people's right of free speech. And again, this case is really a case of first impression, all the way across the board, as far as I can tell. I've only been representing lawyers for 42 years, so I may have missed something along the way. But this is so much different from judicial speech because of the partisan nature of it, and because the person on the other side has the ability to communicate and counteract what's been said. Finally, on the issue of the penalty that was imposed, there's no precedent for that either, because this case is unique, and 60 days is just not in line with what should be done in this case. I know the bar cited the Avon case. A prosecutor ran for judge and maligned his opponent, and he got a public reprimand. The court said, henceforth, you're on notice that it could be worse than that in the future. But of course, the Avon case was, I want to say it was in 21. I tried it, actually. I think it was tried in 21 during COVID, and so it wasn't out there as any type of instruction to someone running for office. And that's, it's another part of why the penalty's too harsh. In judicial cases, judges have Canon 7. They have plenty of guidance. They go to They go before they run. They go to the meeting with the JEAC, and they get told what they can and cannot do. There's no such guidance in this case. We have a 28-year service member who prosecuted for 15 years, no prior discipline whatsoever. And the case is really an admonishment case. And I'm reserving the last minute for my co-counsel. Thank you.
May it please the court, I'm Mark Mason, excuse me, here on behalf of the Florida Bar, and I'm joined by paralegal Melissa Howland. We're here today not because of distasteful political rhetoric. We're not here today to punish someone for voicing an unfavorable opinion. What we're here today for is because Mr. Crowley leveled several false statements accusing his opponent and a race or state attorney of corruption for various reasons. I believe the referee's report, the first one, goes through 7 of those reasons and found in every single case, none of them had an objective factual basis. The argument that this is violative of the First Amendment, that was fully addressed by this court over 20 years ago in the Ray opinion. Issue in this case is not whether this would withstand in a defamation action. I'm not here representing his opponent in the state attorney race seeking redress for defamation. The compelling interest that we are promoting here, that we are serving here with this rule, is to instill public confidence in the integrity of the legal system.
Would you concede that if he had been running for governor and was a member of the bar and made these statements about another lawyer, his opponent in the race for governor, that this would be a different case? And if so, how would it be different?
Likely would be a different case, and I only say that because the rule specifies who, these class of people who you cannot disparage without the objective factual basis, and it's candidates for legal office, and for a governor you don't have to be a lawyer, unlike a state attorney or attorney general or public defender, which is quintessentially that of a lawyer.
So the bar's position essentially is that we should treat this election like, is there any way in which it's not like a judicial election? Is it, or should we, for the purposes of Ray and the rest of the First Amendment cases, is the bar's position that this is identical to a judicial election?
The latter, and I say that because the rule 4-8.2a, it specifies all these classes of individuals, and it groups together judicial officers with candidates for legal office, with members of the jury. All of that is grouped together. So how do you go through this rule, this very short rule, and in this court in Ray says it's an objective factual basis test under 4-8.2a, and then start parsing it out further and say, well, no, for this person it's going to be an objective test, but for this other person it's going to be a subjective test.
So the bar's position would hold the attorney general race to the same standard as a judicial race?
I think it would apply to any candidate for legal office. However, that term ends up getting defined in subsequent case law, although I do admit under the Florida law, I've only seen written opinions in the context of disparagement of judges. But I don't think that's really a distinction that bears any materiality here when you have the plain language of the rule that says what it says. And I think there's a good basis for it. The compelling interest isn't just, you know, we want to protect judges from criticism. We're not trying to protect the person who is the judge. We're protecting the robe, essentially, how people view that title, you know. And yes.
Part of the reality here is that judges are in a different category. In Florida, we don't have partisan elections. There's a whole different realm of things related to judicial elections. But then you've got these partisan elections for state attorney and for attorney general. And it just seems like that having the same kind of rules in both is a little odd. Just given the different constitutional interest in that are operative in partisan elections, where where the parties are involved potentially. And the parties may be say, is a candidate going to be responsible if the political party with which the candidate is associated comes in and does something that doesn't meet the standard that would be okay, that would be applied in a judicial context? It just seems like it's a very complicated thing when we move it over from the judicial context into the context of partisan elections for attorney general. So everybody running for attorney general in Florida has got to be worried about if they make some little misstatement or some exaggeration. That is going to result in them being in trouble. I guess that if once they're attorney general, they can't be in trouble for a while. Under the way that works, they have to wait till they get out. But it just, I don't know. It just tell me why my anxiety over that is misplaced.
All right, I'm probably not going to hit every subject you just said because that was a lot to follow. I'm going to do my best. All right, well, first off, the idea that a candidate's going to be responsible for what their political party might do, that's not the case here. And to isolate that further down, for instance, there were these political mailers that were put into evidence, 2 that were specifically approved by Mr. Crowley, and then 2 others that were issued by a PAC. He wasn't held responsible for what was in those ones that were issued by the PAC without his approval. So we're not holding him responsible for that. As for the notion that we should treat this differently than we would for a judicial officer, this court said, and this is way back in 1952 in the Gluck case, which I cited in my brief, that the state attorney is a quasi-judicial officer of the court with the duty to see that a defendant gets a fair trial. Now, is that remarkably different? I know obviously it's a position of advocacy. You're trying to get someone sentenced or what have you. But it's still kind of the same, a very similar concern as what you're looking at when you have someone like in the Jacobs case that was just disparaging judges and calling them corrupt and saying they took bribes and that kind of thing. So the concern is not substantially different when you're talking about a state attorney or a public defender because it all goes together. And in the comment to the rule, they even applied it, there's a comment about members of the jury. Because the concern is, well, if you allow these kind of statements about members of a jury, that could really cool people in the future from ruling a way that might be deemed unpopular if all of a sudden these lawyers, who are viewed as having this high vantage point with a better understanding, are going to say that a member of the jury is stupid or corrupt and took a bribe to settle the case.
And so you view this as being limited to factual statements, right?
Factual statements,
it has to be
correct.
Sort of by definition, to be encompassed within what's covered by the rule, it has to be, the nature of the statement has to be a factual statement.
It has to be a factual statement. Now, there could be an
hold
issue.
on. So it does, okay.
Yes.
So how does the bar understand factual statements that go to qualifications or integrity?
Well, a factual statement in this case would be Amira Fox is corrupt. That's not a statement of opinion. It's not.
I mean, I don't know if I agree with that. But let's focus on how you define. It seems like there are broad and narrow, relatively broader and relatively narrower ways to read this language.
Sure.
And so if you focus on, if it has to be factual and it has to be, like, it's hard for me to understand in some ways, a factual statement about someone's integrity, how that categorically, that seems like that would be a relatively narrow category of things. Qualifications, if I said, they failed the bar 4 times and that's not true, something like that.
Sure.
I mean,
how
do you define the universe of statements that are even potentially covered by the rule?
Well, one of the cases I cited in my brief is kind of indicative of when it talks about that interplay between something that is an opinion and something that is a fact, and that was Milkovich. And the example they used was, in my opinion, John Jones is a liar, right? It's a mixed statement of fact and opinion, because, the beginning of it says, in my opinion, but then when you say John Jones is a liar, you're implying some deeper understanding, some deeper knowledge.
You're just implying an assessment. I think if maybe the cleanest test case for this is the conviction rate, right? Like, either her conviction rate is her personal conviction rate is 39% or it's not, right?
Right.
Okay, that's a statement of fact, you'd concede, right?
That is certainly a statement of fact.
So if we focus on that one, and if we sort of filter that one through the same analysis that the chief is walking through, if this were an election for not a state attorney, if it were an election for governor, and that sort of clearly demonstrably true or false statement was made, what would the bar's position be in that case?
I doubt it would violate 4-8.2a, only because you're not talking about a candidate for legal office at that point. It could violate 3-4.3, which is another rule he was found guilty of violating, because that prohibits misconduct that is contrary to honesty and justice, which would be cause for discipline. So the question would be, does that statement rise to that level of being contrary to honesty and justice in that circumstance, is how I would answer that question. And then the other part of it, which is part of my cross appeal, is the 4-8.4d violation, which he was found not guilty of, to be clear, and we're appealing that on cross appeal, because that says it's conduct in connection with the practice of law that's prejudicial to the administration of justice. So in terms of...
Is that rule narrowly tailored?
That rule is narrowly tailored. There's no argument to the contrary. The narrowly tailored argument is strictly related to 4-8.2a.
Is 4-8.2a narrowly tailored?
Yes, and I say that because when you're talking about overbreadth of a rule, the case law on that, specifically this court in Williams-Yulee, and then the U.S. Supreme Court on appeal said overbreadth has to be substantial for it to be facially unconstitutional. And the rule has been decided in Ray that we're going to use the objective test, and it's just been applied consistently since then with the objective test. As recently as, I think 3 months ago, this court issued an opinion in the Florida Bar v. Malik Lay, which said you need an objective basis before you disparage a judge. So with regard to 4-8.4d...
Why is it narrowly tailored, though, when without distinguishing between judges and, call it, more policy-based and partisan offices? Is that not enough alone?
Sure. It's because of the compelling interest that's being served, which was public confidence in the integrity of the legal system. That's what the court said in Ray, not in judges. It was, applied in the context of someone that was disparaging a judge, but the compelling interest was broader than that. That's why it's narrowly tailored, because you're talking about people, mediators, arbitrators, jurors, people who are integral to resolving cases. You're talking about the quasi-judicial office of state attorney who's assuring someone gets a fair trial, and obviously you're talking about judges. All of that, and it's only applicable to members of the bar. We obviously can't regulate lay people unless they engage in unlicensed practice of law. The rules are never going to apply to lay people, so it's narrowly tailored because of the context in which we're talking about this in, which is disciplinary proceedings. And just as a final note on my cross appeal, I cited cases, I'm going to try to save some time for rebuttal, about this being conduct in connection with the practice of law. And I say that because that's required to establish the 4-8.4d violation. He did it in his capacity as an eligible candidate for a legal office. What he was doing was trying to attain the highest position you could as a prosecutor in the 20th Judicial Circuit. That's sufficiently connected to establish that rule violation. And with that, I'll save the 2 minutes for my rebuttal.
I just want to say thank you to all you justices for giving us oral arguments in this case. I know that's discretionary. My name is Christopher Crowley. I'm the member of the bar who's at question here today. I just have some brief points because I only have a minute. I still stand by the 39% conviction rate, and the woman I ran against, nice lady, she was the chief deputy under that. I had an expert testify, former chief of computing. When it comes to this religion issue, publicly I stated, I don't know my opponent's religion and I don't care. Some other people said some stuff, I didn't. Okay, just to clarify those facts. When I joined the Army in 1995, I took an oath to defend the Constitution of the United States. Now the Florida bar says the Constitution doesn't apply to Florida attorneys. That's the way I see it. That's the way it should be, and that's the way I'm asking this court to see it. Effectively, the Florida bar is saying the First Amendment rights don't apply to Florida attorneys in partisan political elections. Yes, we're talking about quasi-judicial. This was a partisan race. I lost in a Republican primary. I wasn't running for judge. I'm asking the court today, you justices, respectfully, to stand up for free political speech. Remember first-year law, strict scrutiny? Okay, everything I said I believed in, and I backed up with facts. Okay, we even brought many witnesses to show what I said was true, many articles to show what I said was true. I believe what I said was true. I understand that the referee didn't, but the referee had a conflict of interest, respectfully, that she admitted to. Okay, I'm asking the Florida Supreme Court to support and defend the Constitution of the United States. I thank you for your time. I spoke very fast. I'm a little nervous being up here, forgive me, but it's a long record, it's a long brief. I would ask you all to look at the facts of the case, because we actually put on more evidence at the referee hearing than the bar did. We brought in witnesses, we brought in articles. I believe if you look at all the facts, if every justice looks at all the facts, you should ask what we're doing. And I thank you for your time.
Could you just give us the 30-second version of the 39 of the your argument on the conviction rate thing?
Yes, witness William Smith, who testified at the referee's hearing, who's the former chief of data and computing for the state attorney's office for the 20th Circuit, he got it together, and we looked at all the arrests versus all the adjudications of guilt in the circuit. Now, there's a big debate about, do withholds count, do diversions count, but we said over several past years, like I said, I went to an expert first on this, sir. Okay, I just didn't make it up. And it's a big debate, but that's what campaigns are about, sir. So, I'm sorry. I don't mean to be disrespectful. We looked at all the convictions versus all the adjudications of guilt, and that's where we came for the past 2 or 3 years or 4 years past. And I said that my opponent was the chief.
For the office.
Yes.
For the office. And so basically your theory is that because of her high position in the office,
exactly,
that, she's responsible for the activities of the office.
That's what it said on her website, that as chief deputy, she effectively was the chief executive officer. And when we were campaigning, and I don't blame her, she was bragging about how she ran the office all the time. We went to hundreds of forums. It's a 5-county area. So I said, yes, you have a 39% conviction rate. And I did it in good faith, sir. And I believe it, and I believe it today. And I went to an expert. We actually pulled those numbers from the Florida administrative courts, and we went to a couple counties that provided it as well. The county numbers were very similar when you look at adjudications of guilt over, I think it was a 4-year period, I forget. It's in the testimony of Mr. William Smith. But we came up with the 39%, and yes, I stated it. And we had big debates about whether it was 39% or 85%, but this was a debate that was done in good faith. It was not a blatant lie. I didn't blatantly lie about anything. So there were some independent groups that did some stuff that I was not privy to. I don't think I should have to take ownership for those. Okay. We even objected having those put in evidence. But I'm asking this court, respectfully, to please stand up for the First Amendment. Thank you.
Mr. Crowley said, I don't know my opponent's religion and I don't care. One of his mailers that he approved said, Fox refuses to disavow her direct ties to the PLO terrorist organization, and she won't answer questions about Sharia law. I don't see any reasonable reading of that doesn't put her religion at issue.
What does that have to do, though, with qualifications and integrity?
It has to do with her integrity because he was implying that she was interested in attaining higher office to enforce Sharia law. That's why he shared the American Thinker article that said that.
Like, I'm not sure. I mean, part of the problem is that this rule is obviously the core part of what this rule is getting at is not really, obviously it addresses candidates, but I mean, the main part of this function, the rule is not really, it's not written to govern campaigns. I'm not saying that it doesn't apply, but we're talking about applying it in a setting that's sort of at the periphery of what it's for, and it's written to cover factual statements. We obviously know that in campaigns, I mean, most of what you're talking about is either debatable fact or opinions or mixed or whatever, and then it's even narrower than that because it goes to qualifications or integrity. I don't really know. It seems like if you read integrity the way you do, that would sort of just swallow up. It's really not a limiting word.
Well, first off, I don't believe that this case really does fall on the periphery of the rule if the rule specifically applies to candidates for legal office, and then the comment specifies further that that applies to prosecuting attorney. that seems to be wholly established by the plain language of the rule.
I mean, you don't think that the main point of this rule is to address things that are going on in the context of litigation? You know, the judge is this or that, the jurors are this or that, my opponent, you know, my opposing counsel is whatever. I mean, we don't need to get into a debate about that, but it just seems like you're not. There are things. I mean, this is a hard case, just in general, but it seems like the bar's view of it makes it even harder by not sort of reading the words more naturally than, I mean, I understand prosecutors sort of expand the, you know, prosecutors push the boundaries of the words as far as they'll go, but it seems like there are more sort of naturally sort of limiting ways to read some of this stuff that would take some of this stuff just off the table completely.
The way the bar has interpreted this rule is to apply it equally. So if you have, we cited DuPont, we cited Jacobs, both of them were 91-day suspensions, both of them involve similar conduct, and if the main factual distinction is, yeah, but that was against judges, this one was against a candidate for state attorney, that's just not a distinction that's referenced in the rule. When this court says objective factual basis test in Ray, it was applying it to the whole of 4-8.2a. So the bar just treated it the same as it would if he had disparaged a judge under those exact same circumstances, recognizing he's never had prior discipline, but he refused to acknowledge wrongdoing, and this involves dishonest conduct. We are seeking the minimum amount of time you could have for rehabilitative suspension, which is 91 days.
And having heard what he said about the 39% thing, what's your response to that?
The 39% statistic is false, and
could you just specifically respond to what he said?
Sure. I'll address what he said. What he did was he took total arrests in Lee County for calendar year 2016, and he compared them to total convictions in that same county. That's not going to establish Amira Fox's conviction rate. Those aren't all the cases she handled. It presumes that...
Well, but you're ignoring what he said about her position in the office, and it is not an unreasonable thing to say if you claim responsibility for running an office, that you get the blame for things that aren't going well in the office. I'm mystified by the blindness to that, quite candidly.
The blindness to it, it's not blindness. What it is he took total arrest. So he's presuming that every arrest should result in conviction. That's what you mean. That's what it means when you take that number and you divide it by convictions and say she dropped the ball in these other 61% of cases. There could be a million reasons that there wasn't a conviction, and it doesn't have to do with the office failing.
Okay, we're talking about different things now. You're talking about one thing there, but you're talking about this not being her conviction rate, right?
Right.
And so you think that because it's not her conviction rate, then that it's some more global number, and we can argue about the accuracy of that. Okay, that's a separate issue. But you think it is somehow he's violated his duty when he attributes the performance of the office to her because of her position in the office.
I think that's one aspect of it, and the other aspect is...
I have real trouble understanding that in the context of a political campaign where... that just flies in the face of a lot of a tradition of the way campaigns and the First Amendment works in this country.
I understand the concern, but I would also just point out that it's not even a conviction rate that would apply to the office generally. It was a false figure, even if you're viewing it in that lens and then attributing it to her. Either way, it was false.
What should the numerator be? Number of cases indicted? Number of informations filed?
It's hard for me to really just establish how he would calculate that figure, because very frankly...
You have to, though. I mean, if you're going to accuse someone of making a false fact, there's the issue of what's the universe? Is it just her personally, or there's the office? But then now you're kind of making a technical point about how we're supposed to, like, what would the listener understand conviction rate to mean? And I would think that if you're going to prosecute someone for making a false factual statement, there would have to be some sort of understanding as to what is the quote unquote fact that we're talking. What is the factual sort of measure of this, and is this false in relation to that standard, right?
Well, what I think the issue is he's calling her corrupt, and he's offering that as an objective factual basis to say she is corrupt. And the case law in Ray
now you're mixing other stuff in, and I'm sorry, I didn't mean to.
That's the same point.
No, I don't think I am mixing anything in when he says that's a reason she's corrupt, because under Ray it says when you make a disparaging statement, the burden, we just need to show it was disparaging.
Now you're saying disparaging statement. I mean, this is false. This rule applies to false statements about people's qualifications or integrity. So I don't even know corrupt. I'm not even, to me, I don't even know if what does that even mean to call that a factual statement?
He even put in his brief that it means impairment of integrity. So I think that does apply
factual?
to the factual basis with a 39% rate. That's the part that he is offering as a factual basis to say she is corrupt. That wasn't just a defense in the bar proceeding. He was saying that throughout his campaign as one of the many reasons that she was corrupt or that she orchestrated his arrest. All these different bases that didn't have any basis in fact. And very frankly, the burden was on him to establish that he had an objective factual basis. The bar just had to show that he made those statements that were questioning her integrity or her qualifications, and then he had to establish the objective factual basis. That's the burden shifting standard under Ray.
Okay. It seems like you should have to establish that something's false first before someone then has to defend themselves.
This test under Ray was that we present evidence that the statement was made and it questioned her qualifications or integrity.
So you don't have to prove that it's false.
He has to offer the objective factual basis. That's
okay.
The test.
We probably need to look at that.
All right. With that, I see I'm way over my time. So thank you, Your Honor.
Thank you.
Okay, our next case is RJ's International Trading versus Crown Castle South, number 2024-0547.
Mr. Chief Justice, and may it please the court, Dwayne Robinson on behalf of the appellant RJI. This court should answer the certified question in the affirmative by making it clear that when a litigant prevails in a lawsuit about the use, occupation, or enjoyment of its property under a recorded instrument, that litigant is entitled to the benefit of that instrument's prevailing party attorney's fees provision against all persons who are bound by that instrument. When an owner has a piece of property, they routinely decide what are the terms in which other parties can use their property. These are not mere suggestions. These are integral to the agreements and the terms by which the owner allows someone to come onto their property and use their property.
Is there no distinction between a dispute about the property and a dispute about the cost of litigation? I mean, if I think everything you just said is correct as a description of our decision in Hayslip. The trouble here is we're sort of one step removed, and the question is, does the step matter? Here, the dispute is about attorney's fees after we've settled or resolved, I should say, the dispute about the property. So it's really not, to my mind, a provision about the property or its use. It's instead a provision about the costs of litigation. Now, maybe the same rule should apply. Maybe that does touch and concern the land, and therefore it runs with it. But I feel like that's the argument that I want to hear more about, is like, how does that touch and concern the land?
it touches and concerns the land, Justice Curiel, because here the owner of the property said, you can have an easement across my property, you can use my property, but if you violate that right, you then have the burden to pay attorney's fees if I have to go to court and I prevail on that issue. And so they're intimately tied together. You can't unwind the agreement and say, I'm going to let this clause run with the land, but I'm not going to let that clause run with the land.
But it's prevailing party, correct? So essentially the owner could lose and have to pay the fees. So how would that really touch and concern the use of the land?
Sure, Justice Grosshans, because on the other side of the case, we have Crown Castle. They are the owner of an easement. They are the owner of the dominant tenement. So they have a property right as well. And so here, the prevailing party fees work in both ways. It protects both the served estate, which is my client's property, and it also protects the dominant state. Otherwise, what would happen in this sort of situation is property owners are not going to file lawsuits to protect their property unless they have the mechanism that they agreed would be there to help them protect those rights. No lawyer is going to take on a case like this without an attorney's fees provision. And so in this way, the attorney's fees provision acts to enable a party to protect its rights. In the same way, the arbitration provision touches and concerns the property because it determines where the lawsuit about the dispute of the property will be resolved. In this case, we're not talking about mere procedure. We're talking about the substantive right to be made whole as a litigant who said, you've come on my property, you've torn it up, you violated my easement agreement, now I'm entitled to a remedy. What our friends on the other side here, this is a rule that they want you all to adopt, okay? They want you all to say that an arbitration provision runs with the land. However, a sentence within an arbitration provision that says the losing party pays the arbitration, that doesn't run with the land. So you're on your own to pay for it, but you have to arbitrate. There's no logical way to unwind the agreement and to create that sort of mechanism. What happened in the district court decision, frankly, was just wrong. What the district court did is it looked at the 5th DCA's decision in Kalk. And in Kalk, as you all know, the court dealt with what to do with eminent domain proceedings. Okay, there was an agreement that said if the property is taken by eminent domain, the original owner of the property gets the money, or in another scenario, the second owner of the property gets the money. But as for all the other subsequent owners of the property, they get nothing. Okay, so that was not a covenant that ran with the land to the successive owners. It either went to the original grantor or the original grantee.
Can you explain where the line is if prevailing parties' attorney's fees run with the land? Obviously, in the amicus brief, there's, the idea that forum selection clause and a jury waiver and all sorts of other issues that could arise in litigation would fall into the same category as a prevailing party attorney fee. Do you think that's the case, and should it matter?
Well, as far as agreements regarding waiving jury rights, I think that would run with the land for the same reason that arbitration provisions would run with the land, because it's bound up, it's intimately bound up in this decision. We can't, as a court, unravel the parties' agreement and renegotiate it after the fact. An owner is entitled to the benefit of his bargain. I said you can come onto my property, here are the terms, you either live by them or you go somewhere else. They had full notice about this covenant, they admitted that at the trial level, they should be held to adhere. Going back to Kalk, the district court here unfortunately looked at Kalk as a one-size-fits-all proposition, that whenever you're dealing with money, it's collateral to the land and it has nothing to do with the land, therefore it doesn't run with the property. Frankly, that's contrary to this court's decision in Cove Club, where this court held that an agreement to pay recreational fees was a covenant that ran with the land. And indeed, the district court's reading of the rule is also contrary to the reading of Kalk, as I just explained. Kalk did not create this sort of, one-size-fits-all proposition. What we contest the rule should be is that whenever you're asking for attorney's fees, it should apply to those things that clearly touch and concern the land, okay? So let me give you an example. If you have a situation like in Kalk, okay, where you have this provision that says only the original owner gets the eminent domain proceedings, and I file a lawsuit about that, and there's an attorney's fees provision in that agreement, you don't get attorney's fees for that, because that's not touching and concerning the land. It doesn't have anything to do with the land. Here, it does have to do with the land. We also remind the court that we have an alternative argument that we're asking the court to consider. Judge Lagoa, when she wrote the decision for the 11th Circuit, who previously sat on this court, let this court know that she is not, and the 11th Circuit is not restricting your review and your analysis of this issue. We contend in the alternative that even if you don't want to decide the touch and concern issue and upend the rights of property owners and estate holders throughout the state of Florida, there is a narrow basis in which this court can decide this issue, and that's that Crown Castle is a party to this easement agreement. Okay? If we look,
That's really beyond the certified question.
undoubtedly. I don't disagree, Justice Grosshans, but this court has the jurisdiction to do that.
How would we have the jurisdiction to do that?
Because under the Constitution, you have jurisdiction because there was a question that was certified. But this court can, in resolving the case, resolve it on grounds that are different and distinct. And Justice Legault recognized that. And that's why in her decision, in our case, said you all can resolve this on other grounds than the question that is presented. So the court does have that discretion to do that if you have any doubt. We're totally comfortable with our argument about the covenant running with the land. But if I can just touch briefly on our alternative argument, here we have an easement agreement that was clear in its face. It said the grantee was not just Bell South, which was the other sort of party to the easement agreement, the initial lessee. It said it was also the assignees as well. There's no dispute that Crown Castle as a sublessee was an assignee. It therefore was a party to the agreement. What my friends want you to believe is the only parties that can enforce this easement agreement is the former owner of my client's property, which is Hidden Valley, okay, and Bell South. But Bell South has given the property to them. It said, hey, here, you have the sublease, you run the cell tower, you use the easement. So these are the parties, and we cannot have a situation where a trial court determined you breached the agreement, you breached the easement, you have to pay damages, but this one clause in the contract, yeah, don't worry about that. You're excused. You don't have to pay those attorney's fees.
I understand the argument. I think, taking just a step back for a second, the reason the 11th Circuit certifies a question to us on an unsettled matter of state law that's determinative of the cause before the 11th Circuit is not because they want us to determine the cause. It's because they want us to answer a question of state law so that they can determine the cause. It's their case. So while I appreciate the argument, it seems to me like you should stick to, this is here because they want us to answer a question. I'm curious about whether the question that you are addressing right now is really, I could see if they certified that question too, where we would have a hook, but
Well, then let's stick with the certified question if we can. We've cited to a number of authorities.
Can I ask you on that? In your brief, you note that you're asking us to find that prevailing party provisions that grant a remedy for violations of real covenant are the ones that run with the land.
Yes.
So is it kind of your contention that there could be prevailing party provisions that would not run with the land? Or are you saying they all are going to? I just want to clarify what you're asking.
Sure. I can't imagine a prevailing party attorney. Let me correct that. So there is an instance in which we do acknowledge attorney's fees would not run with the land, and that's where the parties are litigating a personal covenant that is not touching or concerning the land. That's logical. But as it pertains to litigating a covenant that does run with the land, such as whether or not you violated an easement by digging it up and installing cables without permission, that does run with the land. Because if not, let's think about what that says to the owner. That says, okay, you breached the agreement. We had agreed that if you did that and I win, you pay me attorney's fees. Now you don't have to pay attorney's fees. You can come back again, tear up my property, and I'm going to file suit, and I know that I'll never be made whole. I'll never, even if I get whole for damages, as far as the amount I have to put in to litigate this case, I will never be made whole. And this court recognized in the Cheek decision that that is one of the benefits of having an attorney's fees provision, is to be made whole. Otherwise, no rational owner is going to file a lawsuit to let's say, get $5,000 in damages when it costs them $50,000 to get it. And so what will you do? You will stand on the sidelines and allow violation after violation after violation of your property. Or if you want an injunction, are you really going to seek that injunction? Or no, you're not going to do it because you're not going to have the mechanism. We'd encourage the court to look at the Flying Diamond case. That's a case that both parties have cited in their briefs. We think it has two critical elements in that case that talk about touch and concern that's relevant here.
If we don't accept your contention that attorney's fees are a remedy, we don't think they're really part of the remedy, do you lose?
No, we don't, respectfully, Justice Gross-Hands, because even if it's not a remedy, it's still a part of the agreement. It's a part of the bargain that was struck, the terms that were set forth. And in this situation, we need to uphold the predictability, the fairness of real estate transactions in the state of Florida. And so if I'm an owner and I say you can use my property under these circumstances, those are circumstances in which you're allowed to use my property. And if you don't, then maybe I don't want to do this agreement anymore. But the thing is, we're bound. We took this deed, we took it, subject to those covenants, and we're bound by it, and they're bound by it, and they have to live by it.
So on that point, do you see this more as a case about the language of the agreement or about this kind of broad issue of whether prevailing parties' attorney's fees touches and concerns the land?
Well, Justice Sasso, the language of this agreement certainly helps us because it's very forceful in its terms. Section 5, for instance, is very clear that the covenants are intended to run with the land, but I think even beyond just the technical requirements or specifications in our particular agreement, it's the concept, it's the principle that matters. Who gets to decide what happens when you violate an owner's rights? There's a private law here that was created, the contract, the easement. And
yeah, so I guess that's, to me, it just seems like this is more about contract law than some common law rule on what touches and concerns the land. That seems to be what these cases turn on. And so I guess just in tailoring an answer to the question in this case, why would it not be, specific to the agreement here?
I think if the court wants to rule that way, it should do so. The one thing that I think is paramount to do or not to do is to upend the rights of Florida property owners by agreeing with the holding of the district court that attorney's fees provisions just do not run with the land. That does not make sense in reason. It doesn't make sense in logic. The Flying Diamond case we cited makes it very clear that you look at the purpose. What is the purpose of the money? You don't just simply say because money's involved, it doesn't run with the land. What is it there to do? And here, the money is designed whether as a remedy or as a mechanism to get access to the courts to protect your property rights. It's there. If there are no further questions for the court, I would like to reserve the remainder of my time for rebuttal.
Mr. Chief Justice, and may it please the court, Jacob Cohn from Gordon Reese Scully Manzacani for the appellee. With me at counsel table is Eve Kahn of Baker Donaldson. The issue here is whether an easement provision with an attorney's fee runs with the land. Chief Judge Altanaga wrote a very good opinion. It's the opinion we stand behind, and she rather convincingly concluded, based upon an eerie prediction, that this court would agree that a attorney's fee provision is collateral and personal and does not run with the land in a real estate easement.
How would you best distinguish this from Hayslip?
Well, Hayslip, to begin with, the nature of touch and concern is not talismanic. We go back to Spencer's case, 1583, which I read yesterday in preparation for arguing here. It is a balancing of competing interests of when do you draw the line, okay? And you always want to facilitate the intent of the grantor. You always want to facilitate the free alienability of land. Those are always in tension. What are the differences here? Hayslip was an arbitration provision. Hayslip, we love arbitration. Arbitration is a favorite of the law. Attorneys' fee shifting is fraught, and it is.
Well, in Hayslip, the deed that we had has an arbitration provision that we enforced. As a subsection of the arbitration provision, it has how fees and cost of the arbitration will be handled. Does that run with the land?
I don't think that's before the court.
And I think that's an
you're
interesting,
gonna say this is
that is an
different.
interesting question, and I don't think that we need to go
But you're
down
asking
that.
us to write an opinion that says attorney's fees do not, prevailing party attorney's fees do not run with the land, even though we've said arbitration does, which is the method of resolving a dispute about the land. So would we then have to distinguish, well, if the attorney's fees are part of the arbitration provision, maybe that's different. I mean, you see that there's a lot of issues that come from us making that
yes.
statement.
I see the complexities of where this can go in different situations. It can go different ways, perhaps, when you have a homeowners association, when you have planned unit development. A lot of this ends up being resolved in Florida by statute.
Chronologically speaking, Chief Judge Altanaga decides this case and makes an eerie guess before Hayslip comes out, right? Or after?
No. The opinion of Judge Altanaga very much addresses Hayslip.
Okay.
And says that the distinction here with Hayslip, give me 1 second, is all of the things that are listed out. It touches and concerns the land because it doesn't arise until you have a injury to the land. Of course, this doesn't either. It dictates the means for seeking to rectify the building defects. It's triggered when a defect is realized. The outcome of the arbitration proceeding affects the land, and the owner benefits directly from the arbitration result, whereas even the 11th Circuit, Judge Altanaga recognizes this is a step removed. And when you look at Cheek, which they like to cite to, Cheek says attorney's fees are not part of the remedy. It is a personal covenant. It doesn't enrich the estate. It doesn't enrich the real property.
Why is that the case? I mean, why wouldn't a property owner be justified in saying, I am not going to grant an easement on my property unless I have some indication that litigation, which is almost certain when you have an easement, that if I take the correct legal position, I'll be entitled to fees? Why would a property owner not, in terms of deciding whether or not to grant an easement, take that risk into account and only grant the easement with the prevailing party attorney fee provision?
Well, that is certainly a matter of contract. This is a question of common law, real property, what passes with the land and to what extent.
Well, but you said at the outset that we're dealing here with the weighing of things. So weighing, I think you said in this context we're looking at weighing giving effect to the intent of the grantor, and also the effect on free alienability of the land. Those are two things you mentioned, right?
Yes, there's a deeply rooted concept in the common law. If the court wants to redefine the common law, and this goes back, and the cases that Judge Altanaga cited to be from other jurisdictions where there is no question in those cases that attorneys' fee provisions are personal covenants. They are collateral to the estate.
Let me get back to my question. I understand your point there, but let me get back to my question about the intent of the grantor. How does that cut here? Do you refute opposing counsel's position that the documents actually, if you just look at the documents, put everything else aside, put the common law aside, you just look at the documents.
May I short circuit this? Notice is not at issue here. Intent is not at issue here. Touch and concern, whether it is adequately concerned with affects the estate in land, is the issue that is before the court.
If we look at the intent of the grantor, and we think that really, in the balance of things here, that should be predominant, then you're saying you would lose.
If you decided that were not tempered by other concerns, you would probably rule that way.
Help me understand the other concerns. I don't really understand the weight of the other concerns. I know they're historical things for a lot of reasons. We have them, and But sometimes we don't, that's like hard to figure out exactly why, given contemporary conditions. And I'm not saying that means we just dispose of them without thought, but I don't really understand. I'm grappling with a compelling reason to defeat the intent of the grantor in this context, particularly given the precedent we established in Hayslip.
Well, you're making here an exception to the American rule, and if you build it, they will come. The argument on the other side is...
Well, the parties made the exception. The grantor made the exception to the American rule. We're not making an exception to the American rule. The grantor did it. Isn't that a fair way to look at it?
That is a way to look at it. I believe that if you want to remove touch and concern the land from the historical antecedent of all of this, and just say whatever the grantors put into something and the original grantee accepts, we're going to pass that down. That is a new that just upends the historical antecedents and says we're just going to do it this way now. I can't tell you, you're the Supreme Court of Florida, I can't tell you can't do it that way. But if we are going to adhere to 500 years of common law precedent brought forward to the present time.
I mean, but I understand why you're posing it as an all or nothing, because it's an argumentative strategy. But we could still say that, for example, a purely personal obligation would be different. Like if the deed said, and shall sing, Frank Sinatra songs on the property, that I think we'd be able to pretty safely say does not touch.
Well, that's consistent with the existing common law. Right. The question you have to decide is, where is it, if we're going to accept the general rubric of the common law that it has to be directly tied or at least tied enough to the enjoyment of the property right, then we need to go back and look at, do we want to have fee shifting? This case is an example of what happens when you have fee shifting. You have a relatively de minimis case of somebody. You have two pieces of this. You have factually, you have whether or not the easement allows you to bury cables under the easement. They buried cables under the easement. They got $1 for that. They got $1 for the breach of the easement. They got a peppercorn. They came in wanting millions of dollars. They got a peppercorn. If you look at the amount of attorney's fees expended, they're now seeking 600 hours of attorney's fees, over $300,000 for a peppercorn. On the actual, then there's an actual trespass here where somebody messed up and wasn't on the public right of way, instead buried some cable not in the easement, and they got $40,000 of trespass damage. I mean, when you set up a fee shifting regimen, or when you bless it, then you end up with unintended consequences.
I guess the problem is, and I'm not defending Hayslip, but we arguably kind of cut the cord with the historic understanding of touch and concern in that case. And it seems like now, you're asking us to sort of do this kind of, this far but no farther type thing. And I understand that I think it's interesting that the whole arbitration is favored, attorney's fees are disfavored, but it seems like that sort of rationale is just it's kind of far afield from the question of like continuity with this area of the common law going back.
Well, I think Hayslip, I note that the Supreme Court's opinion did not tie Hayslip to the arbitration interests like the Circuit Court of Appeals did. They very strongly, and around the country very strongly, look at the balancing of the overarching interests and says, yes, this does, and if you wish to look at it as cutting the cord, which I don't think the court did, and the court certainly didn't write it that way.
I mean, do you think Hayslip is do you view that as if Hayslip had been decided 500 years ago, would it
500? I'm sorry.
I mean, you know what I'm saying? It sounds like it's pretty. The origin of this concept was much more limited, right?
Well, 100 years ago, which led to the adoption of the Federal Arbitration Act and the State Arbitration Acts, there was judicial hostility to alternative dispute resolution.
No, I'm talking about
there still might be. I don't think the judicial hostility is necessarily valid. I'm not saying on this court.
I'm talking about touch and concern, whether that type of a provision would have been historically considered one that touches and concerns.
Well, I would argue not.
Okay, that's my point.
I would argue not that historically this is not considered part of the remedy, not part of what is the interest in land. The interest in land is protected. It's easy to say the interest in land is protected. Go sing Frank Sinatra at my house on Tuesdays is collateral. Okay.
Isn't that the purpose, though, of the common law rule is developed is to distinguish between covenants that are personal and those that run with the land. It's not this prohibition against certain categories of covenants running with the land, right? In other words, if something that somebody might typically consider personal is incorporated in a way that runs with the land, it doesn't make that contract illegal. Well, right. No, this is a common law tool to distinguish between types of covenants.
If you look to the easier historical antecedents and you say, as part of being the tenant of this property, I am going to maintain the farmhouse, then it's on there. It's personal things you need to do. I'm going to mow the lawn and everything and keep everything nice. To pass that along, it has directly to do with the property. And to the Chief Justice's question of Hayslip, that was an argument. That was the argument. It is too far. It does not touch and concern. And the reasons that it did were that the dispute itself is about the property. It touches and concerns, and it is basically how do you administratively deal with a dispute, and does
right,
that go on?
The
they said
recording
yes.
process has taken away that administrative dispute for the most part, right? Because the parties all have notice of what's in the agreement, what other parties have agreed to that goes with the land, that comes with the obligation. They can buy it or they cannot buy it. They can enter into the lease or not enter into the lease.
That is true. So frankly, the restatement third suggests that Massachusetts has adopted that. If we're to hew to the common law, and then we are back in this imperfect, but it's been working along for 450 years, and you're going to have to make a call here. Do you want to have these sorts of disputes brought with the fee shifting and all of the economically irrational get the lawyer paid things that come with fee shifting, that come with.
But again, I mean, we've got two kind of venerable things in collision here, or in tension. You've got the venerable rules of the common law, and then you've got this not inconsiderable principle of freedom of contract. Mm-hmm. And the people, the parties who entered this originally, they decided they wanted that, and they decided that would apply to their successors. And so you're asking us to defeat their intention based on this other venerable rule. And I understand. I mean, that's your job, okay? Yeah, that's your and it's in your client's interest. And there may be sometimes people, the intention that people carry out has unintended consequences even for them. But okay, we have this principle of freedom of contract. So that's kind of what we're dealing with here.
I
Isn't
understand.
that right?
That's fair, but let me share with you something that is quoted from Keogh v. Peck. I like history today. 1931 Illinois App, and they quote 15 Corpus Juris, CJ1, not CJ2, 1245. No agreement between the parties, however strongly expressed, can cause a covenant to be attached to the land if it is not of such a nature that the law permits it to be attached, although such an agreement may create a lien upon the land as against a subsequent purchaser with notice, notwithstanding it will not bind such purchaser personally. That's an accurate statement of the common law. And so, yes, does it put the bunny in the hat? A little bit.
Counsel, under your theory and your argument, would a waiver of jury trial follow more closely with what we decided in Hayslip or with your argument today?
I would see, if you're going to enforce an arbitration clause, you've waived a jury. So I think...
Let's say it doesn't have an arbitration clause, it just has a waiver of jury trial provision in the deed.
I would say, if I had to pick one, absent more, that it would be more in the nature of a personal choice. And by the way, most of these, it's largely irrelevant in an easement situation because a lot of this is you're suing an equity where you don't get a jury anyway.
Right, I understand, but the question we're being asked involves Hayslip and real covenants. And
Understood. There
jury waivers are certainly right up there with arbitration and all of these.
Frankly, if you look at the, this is a very odd vehicle to present those sorts of issues. So it's difficult for me to argue it from the perspective of this case, but I understand the question. You understand our argument. If there are any other questions, otherwise, any time to reserve, but I will yield back my time.
Thank you.
Thank you, Your Honor.
What's interesting is what we did not hear just now. The Crown Counsel did not argue to this court that it should overturn Hayslip. In fact, we're all in agreement that Hayslip was properly decided in this case. And in Hayslip, apparently there was an attorney's fees provision in that agreement as well. And simply, it does not make sense. Justice Gross says, you ask counsel a very simple question. How could it be that the arbitration could run with the land, but not a provision requiring you to pay for that arbitration? We raised that issue in our briefs. We still have not gotten a straight answer from Crown Counsel about how that can be the case. This court, in upholding unanimously the right that arbitration runs with the land, did not rely on general principles of favoring arbitration. That's absent from the decision. This court did what courts are supposed to do in this context.
What about a provision that selects counsel or selects who the arbitrator is?
I think that's a closer question. I don't know how. Again,
the arbitrator in this case. Imagine that the grantor didn't trust people who went to Harvard. I don't know why such a person would exist. But let's say the provision said, the arbitrator in this case shall in no event be a graduate of the Harvard Law School. Does that touch and concern the land?
I don't think so. I don't think so, Your Honor, for the reason that it doesn't essentially. It's still you're protected in your mode of deciding how the issue is going to be granted. But it's the same thing as your analogy about singing on the property. It may be nice. It may be nice to have non-Harvard graduates, but that in and of itself is not going to affect your rights in terms of protecting your interests. And so in that sense, I think it's an interesting sort of question, law school question, but I don't think that it actually affects the outcome in this particular case.
Well, no, but we have to, as Hayslip, which is a 2022 decision, demonstrates, you lay down a rule and there are consequences. And so the rule we adopt here and respond with to the 11th Circuit is going to have application in cases other than this one. And so the question is, if this is, as the Chief was calling it, here but no further kind of exercise in rule drawing, what is the line you propose that we write so that we don't wind up having a bunch of personal covenants, or perhaps you're arguing that we shouldn't worry about this common law tradition anymore, because to the extent that any of these promises impact the economic value of the land, that's what matters. I mean, like, which is it?
Well, we're not asking the court to overturn its years of precedent as to what touches and concerns the property. If you're asking me the question as to what the rule the court should draw as to attorney's fees, I'm happy to articulate it. If you're asking what is the line that we should draw in terms of other things that may come down the ramp, such as jury trial waivers and such as selecting who your arbitrator is, frankly, and I know you're not going to like this answer, that isn't the question that's before the court. And there's an important reason why this court shouldn't do that. You didn't do it in Hayslip either. In Hayslip, this court didn't say if it's an arbitration that's about the land, then it runs with the land. This court just simply said all arbitration provisions run with the land, and you stop there. And we're simply urging a similar concept here. And that's to decide the case that's before you based on the facts that are before you. And we would simply say that if an attorney's fees provision directly compensates someone for prevailing on an issue that touches the concern of the property, those two things should run together. The benefits and burdens must run together, or they cannot run at all. So that's the way that I think I would articulate it. We do recognize that, yes, new cases may bring new issues, but here this is a straightforward issue that the court should resolve in our favor. And here's the reason why I think this court should uphold, as Justice Kennedy raised, the grantor's design here. And not only the grantor's design, but the counterparty's design as well. Because if you don't do that, if you allowing these covenants to sort of fall off the track when the property is moved to someone else, you can have a situation where a grantor says, I will let you have an easement to own my property. Then the very next day, the person who has easement then transfers or subleases that agreement to a third party, and then says, arbitration, you're out the window. Attorney's fees, you're out the window. And I'm now out of the deal that I made just the day before. We have to uphold the covenants, the promises that were made that were integral to the formation of the agreement. And for those reasons, we ask that this court answer the certified question in the affirmative and hold that in this circumstances, attorney's fees not only can, but they do run with the land. Thank you very much.
Thank you. We'll be in recess for 10 minutes.
All rise.
Okay. In the Florida bar, the respondent was. That's what I wasn't. That's why we weren't sure. Flipped a coin.
All rise. Florida Supreme Court is now in session. Please be seated.
Thank you. Our next case is Lumpos versus Bank One 2024-1256. And I apologize if I mispronounced your client's
You pronounced
name.
it correctly, and
Okay.
May it please the court, John Goldsmith. I represent the petitioner, Linda Lumpos, also known as Linda Maragudakis. And we are here the court is here to determine what one sentence of a statute means. And of course, the first canon of statutory construction is that what the legislature says in a statute is what it means. And that means that the court should not add language or take language away from the statute and should give meaning to each of the words that are present. And to graphically illustrate this, in my reply brief on page 2, I set forth, this is what the statute says, and this is what the respondent asked the court to do, which is to remove two words, which is any deposit or account made of. They want to remove deposit or, and then they also want to add the language and is established in the accordance with the unities of possession, interest, title, and time. That's not what the statute says. The statute says any deposit or account made in the name of two persons who are husband and wife shall be considered a tenancy by entirety unless otherwise specified. And if the legislature intended to require tenancy by entirety to have these unities of possession, interest, title, and time, it could have written it that way.
Could we, so I commend your focus on the text. When we start, it says that any deposit or account shall be a tenancy by the entireties.
Yes, Justice.
So I am inclined to give effect, as you say, to every word, and that here, of course, means the word deposit. But is it possible to have a tenancy by the entireties in a deposit, but not the account?
The answer to that is I don't think that there is. And
so then how does that disjunctive, deposit or account, make sense?
The important part of that is, and it is the canon of statutory construction, a linguistic one, and the Latin word is nostratura associis, which is
we know it by its friends. So who's
by its associates?
Who's it hanging out with here?
So who it's hanging out with is account, and because excuse me, the words deposit, account, and made are all in proximity to each other. You can make a deposit at any time. Also, an account can be established at any time either. The fact that they're trying to say it's only when you open the account that's when it's made, I don't believe is an accurate statement.
The text actually says made in the name of two persons.
That's correct.
So, I mean, to me, that suggests that if the account, whatever has happened before, if at some point that account is made by some documentation in the name of two persons who are husband and wife, then it's a tenancy by the entireties under the statute. That's the core of your argument, right?
That is the absolute core of the argument. Is that when they went in 7 months after the account was established, and they added her to the account, that the account was then made in the name of the husband and the wife, and it's a tenancy by entirety account.
Now, I think what the second district, in a very thoughtful opinion,
yes,
I think the second district really has a better understanding of Beal, because I think the other district court kind of overlooked a lot there in thinking that somehow resolved this or could.
I don't disagree with you.
Okay. So it's a very thoughtful opinion, and so respond to what the second district would say, that the way that you and I have just interpreted that part of the text really is not clear enough to overturn the common law rule about the unities. So how do you respond to that? Because that's really the heart of what they say, I think.
Yes, that's exactly right. And I would say three things to that. First, they cite a substantive rule of statutory construction, which is that if you pass a statute in derogation of common law, it has to be clear, it has to be repugnant to it. Well, first, this is clear and repugnant because it says nothing about the unities. It only says any deposit or account made in the name of two persons who are husband and wife shall be considered a tenancy by entirety. So it is repugnant to that. But secondly, you can have both. You can have, and this is what Missouri recognizes, and that was my supplemental authority, is that Missouri recognizes a statutory tenancy by entirety. But even if you have a statutory tenancy by entirety, if you don't meet that, you can still have a common law statutory. You can still have a common law tenancy by entirety. So they're not inconsistent with each other. But the third point that I would make is the point that Justice Scalia makes, which is that that when you take a provision like a statute of derogation of common law, that it has to be clear and repugnant. That's a substantive type of statutory construction, and that the focus should really be on a linguistic statutory construction. What does the statute say? And
but I mean, one of the basic tenets of the whole Scalia thing is that, context is critical.
Yes.
Statutes are written with an understanding of certain backdrops. Every new thing sort of jumps, kind of enters the sea of all the surrounding law. And I think his sort of gloss on the whole derogation of common law thing isn't so much for courts to be telling the legislature how you have to do things, but sort of setting kind of default rules about how we're going to understand what new lawmakers think that they're doing or are doing when they add things to this, sea of existing law. And so I think the second DCA, which I agree with Justice Kennedy, I think tried to do a good job of kind of understanding, not just sort of focusing kind of myopically on the one sentence sort of by itself, but to sort of understand what's the legal backdrop against which the legislature did this, and I think making, a reasonable assessment of that.
Yes, and I think that Judge Kelly, in her opinion, does go through and make that type of an analysis, but with all due respect, I think the mistake that she makes is her focus on the fact that her assertion that it's not in that the statute would interpreted the way that I suggest is not in derogation of the common law, and I don't think it could be more clearly in derogation of the common law, because it's very specifically does not include the six unities, or it includes one unity, the unity of marriage. And if it wanted to include the other five unities, it could have done that. The legislature knew what it was doing, and the fact that it did not include any of those other unities is clear that that's what it intended. And the Missouri statute that I cited has been interpreted over the years, have been in existence for a long time, in the same manner, that there is a statutory tendency by entirety that is created.
What is the significance of the legislature saying shall be considered rather than just is?
In the language, I think that it is a mandatory statement that it shall be considered, and the only exception to that is if there's fraud, undue influence, things of that nature. That's the only thing that can affect it. So saying it shall be, it is making it it is direction, it is certainty. It's not a rebuttable presumption, which is what existed under the common law, where certain things might be present. You might create a rebuttable presumption about things, and that's part of what the Beale Court was dealing with in terms of this court talking about, is there a rebuttable presumption?
And so essentially, it's just kind of a clunky legislative language for is, right?
It is, and we mean what we're saying, and we could not be more clear about that. And so that is really the focus of the argument. The only other points that I would like to make is that the second district also points to the first sentence of 655.791, where it says, in connection with the opening of and maidenness of an account. It says, gee, well, that shows that the legislature knew how to say something differently. Well, first, that was part of the statute passed in 1992. This was passed in 2008, and the fact that they elected to put it in that part of the statute doesn't really provide any meaning. And again, the language of this statute is clear, and the alternative, and what the legislature is clearly trying to get at, is to prevent the need that if somebody comes in and they want to add their spouse to the account, that they don't need to close the account, probably move to another financial institution, so there's not an argument that it's a mere continuation. that's a type of policy decision that the legislature was clearly making. And the last thing I'll state is that, you know, that the respondent's brief says it would lead to absurd results because you could have one person have a tenancy by entirety account, or you could have people who are not married have a tenancy by entirety account. But the statute specifically says an account made in the name of a husband and wife, which requires two people who are husband and wife. So
let me ask you a question about the kind of underlying rationale for the unities.
Yeah.
And this actually relates to a similar question that we were dealing with about common law, the case before us,
Yeah.
the preceding case this morning. Are those rules really about trying to figure out what the parties intend, at least in part, of trying to understand? You have the unities as a way of understanding a particular intention of the parties. Is that related to that or not?
I'm not sure that it is. It could be, and that might be
what is it about? What's the purpose of it?
It is a type of a common law formality that in the present context probably doesn't make sense. It is a law for all other personal property, and the legislature has debated whether to abolish it as to other personal property. But I don't know what the purpose of having those all of those unities in place. It's a kind of formalistic type of system.
Isn't it to privilege the institution of marriage?
Well, of course, the purpose and the purpose of having tenancy by entireties originally was the idea that you might have a husband who would go off and wildly pledge assets that are owned by the husband and the wife, and it was really to protect. 150 years ago, it was to protect the wife. But the idea is really now to protect either spouse. It's that the unity results in the fact that the property is not owned by the husband or the wife, but it's owned by them as a joint separate entity, like a limited partnership, like a corporation. That's kind of the idea of what the whole purpose originally for the tenancy by entirety accounts are. And that's really what we have in this situation, where it was created in the interest with the assets of the husband, so that it would be in the name of both of them by tenancy by entireties. Thank you.
Good morning, Your Honors, and may it please the Court. I'm Aaron Miller from Shafferts & Associates on behalf of the appellee respondent, Dove Investment Corp. As counsel has pointed out, we are here on a question as to the one sentence from 655.791 and to resolve the conflict between the opinions of the 2nd District and the 4th District. In other words, it needs to be decided whether the legislature abrogated the unities of time and title to create an entireties bank account when it amended statute 655.791 in 2008. Contrary to the petitioner's argument, we're not seeking to rewrite 655.79 sub 1. Rather, we believe, as did the 2nd District and the courts that we cited to in our briefs like Benzaquin, Southern Account Services, that the proper inquiry as to whether a bank account is an entireties account, first you have to start with the required unities. And these unities, of course, we know what the common law is when it comes to establishing entireties bank accounts, as this court stated them very clearly in Beal Bank.
So, but what's the purpose of the unities? Well, I mean, okay, we have these common law rules. They have some purpose. They're helping. They're default rules in some cases, arguably. that are designed to serve some purpose. What's the purpose of the unities?
Well, as counsel had pointed out, and I would actually tend to agree with it, the history of the concept of tenancy by the entireties is that, and as also expressed by this court in Beale, that the asset, be it real property, a bank account, whatever it happens to be, it's not owned by any of the individual spouses, but instead it's owned by the unity.
I understand that. I understand what a tenancy by the entireties is. But, and I understand the public policy in support of having such a tenancy that protects marital assets from the individual creditors of parties to the marriage. I understand that. But what are the unities about? What purpose do the unities serve? And I don't. So help me understand that.
Well, the unities, I think, are.
I know they serve your purpose, but aside from that, what public policy? Because the common law is about public policy, right?
I don't know so much that the common law can be described as being about public policy, but it's the historical context by which our laws in our society has sort of evolved over time. So the purpose of the unities, I think the best answer I could probably give is that it's the rule book for how to get to that end goal, how to create that sort of asset, that you have to follow these steps.
I know, but he's asking you why those particular unities?
What public purpose is served by requiring people to jump? Now, I understand if it's about figuring out whether they intended to have a tenancy by the entireties. If we're going to look at these things that happen and nobody's invoked the word tenancy by the entireties, we're going to say, oh, if you're married and these other things happen, yep, that's a tenancy by the entireties. That's one thing. That's a default rule for us to figure out what the intention was. But aside from that, where the parties, I'm struggling to see what purpose the unities serve when you know that there's a desire to establish a tenancy by the entireties. I'm just kind of at a loss as to why people ought to have to jump through hoops when they can clearly express their intention.
Well, I think, again, going back to the historical context of it all, we have these unities or these rules, and really, honestly, I think it boils down to the passing of property. What happens should one of the, joint tenants, or be it not a tenants by the entireties, but some other sort of common tenancy, like tenants in common, a regular joint tenancy with rights of survivorship, or anything like that, what to do with that asset upon the passing of one of the owners.
Well, but that doesn't really. That's kind of jumping to the end point. Now, we understand what the consequence of having the tenancy is and the different types of tenancy and why that makes a difference. The right of survivorship as opposed to not having a right of survivorship, and the tenancy of entireties where both parties to the marriage own the whole property. But just trying to understand the unities and what purpose that serves, I'm still...
I think part of this too is one way to understand the statute sort of in context of what came before it, I think, might be that if there's something sort of fundamental about the unities that you can't really take away and still have this tenancy by the entireties, that maybe that would be a reason to not view the statute as having, quote unquote, abrogated that aspect of the thing. Or if the statute, by just kind of declaring that this shall be considered tenancy by the entireties, do you then essentially sort of leapfrog over whatever you were getting out of the unities, and then you're kind of off and running and it doesn't matter?
Well, to get to that end point, and we're dealing with these common law principles. Candidly, I wasn't around when they came up with them, so I didn't really have much of a say in why we have these particular. But these are the rules that we do have, and these are the rules that we have to live with, and within our system that we all sort of reside.
Isn't your stronger argument here that whatever the common law background is, when a statute abrogates it, we kind of expect the statute to tell us so. And here there isn't a clear sort of renouncement of the common law. Isn't that your better argument?
Yes, Mr. Justice. It is our stronger argument.
All right, so why aren't we making that one?
I'm sorry?
So why aren't you making that one?
I think he was trying to.
Answer Mr. Justice Kennedy's question.
I'll give him the blame for that.
Can I ask you a question? Because it seemed like where you're going was asking us to look at the common law tenets by entirety first and then go to the statute.
Yes.
Why would we not start with the statute when the statute governs? This is an issue of statutory interpretation, right? Well, so the second and the fourth did. They were trying to interpret a statute.
Yes and no. It's sort of a little of column A and a little of column B, because here we have a statute that would be in derogation of the common law. It's trying to change the common law.
That's a substantive canon of interpretation of a statute. It's not a method for determining whether or not these types of accounts are in fact ones that are tenants by entirety. So we have to look at the statute first. Right?
Yes, okay. But in the language of the statute, it uses the word made. It doesn't say augmented, amended, changed in any way. It says made. That is the word that the legislature had used. Now, counsel would also
deposit.
I was just getting to the word.
Yeah, it's a little. The formulation is a bit odd.
I was just about to get to the term deposit used in the statute. Now, this was the idea of a deposit was not something that was an issue in this particular case, and I kind of feel that trying to use the word deposit or bring in the word deposit when trying to determine what the legislature, or the statute, I'm sorry, not what the legislature, but the statute says account made is a little bit of a deflection. However, the issue below, again, it didn't involve a single or series of deposits. Rather, the issue that we're here on is whether the bank account itself was an entirety's account. And also, if we're going to be looking at a deposit, just like we are arguing, or that our position is that the account is made when it is created, that is a singular point in time. A deposit is a singular point in time when those money or whatever is transferred into the account.
In a much more natural reading of the text here, to read that, to understand that an account is made in the name of two persons when there's some paperwork that says this account is in the name, we're making it in the name of these two persons who are husband and wife. If you fill out the paperwork, that you made the account in their names.
Well, and that is one of the crux of our position. You make the account when you open it. If you want to add somebody to an account that already exists, the account has already been made.
But you can also make an account in persons' names by submitting the paperwork that establishes it from that point forward that it is in their name.
But the account was already made.
Well, you have a very limited understanding of the word "made."
Well, does the tendency of the entireties rule? Are you saying that it builds into under that rule is the making sort of, that's the unity of time? Is that part of the argument?
Yes, and part of our argument is that the amendment to the statute, it didn't abrogate the common law, and they can coexist. They're not mutually exclusive of each other. So that when a husband and wife make an account, and again, we have to remember the historical context of what brought about the amendment to the statute, and I think there's plenary authority discussing this, where it actually stemmed from this court's opinion in Beale, where you had a situation where a couple would go to a bank, they would open an account together, and and some banks do this, some banks don't. They just give you a signature card without like a menu of options of type of ownership. So do you want it owned as tenants in common, joint tenancy, multi-party sort of account, tenants by the entireties, and then all sorts of, pay on death designations. Some banks have a very comprehensive sort of signature card, so when you open an account, you're given this menu of options to choose from. And in Beale, all of the unities did exist, and the questions answered by this court were premised on the fact that all 6 of the unities did exist. But the situation was where you just had sort of a plain Jane signature card where there was no designation as to type of ownership. what are we supposed to do in that sort of situation? In Beale, this court, the opinion was such that, here you have all of the unities. Just because you don't have some express indication on the signature card that is to be owned as tenants by the entireties, that we will presume that it will be tenants by the entireties. When the legislature amended the statute some, 7 or 8 years later, it was largely, I would think, because of the footnote in Beale kind of asking banks to, hey, clean up your signature cards because it's kind of confusing. So now the legislature stepped in.
How long was that after the Beale decision?
Was it 7 years or 8 years?
I mean, I think that the notion that 6 years later the legislature responds to a footnote, I just don't know.
Well, and as we provided in our brief, the legislative history of the amendment to 655-79 actually specifically references Beale. And the sort of request or the suggestion by this court that the statute be changed or amended to sort of eliminate this ambiguity as to what happens in a situation where you have just this sort of blank signature card that doesn't really list out these sorts of options. And that is in the legislative history. So although it was 7 years later, I guess it was still fresh in the mind of the legislature when they enacted the amendment to 655-79.
So then, can you just be clear then? So that were you? Because I mean, a lot of the questions have been about what did this not do, but what are you saying affirmatively that the statute did do? I mean, you kind of assume the legislature enacts a new provision to accomplish a particular result. So. And you're trying to sort of distinguish sort of what they took as the backdrop and kind of intended to retain as the backdrop, but they obviously were trying to change some of the backdrop of the existing law. So what were they trying to change?
Well, they were trying to eliminate this ambiguity when you have a signature card that doesn't indicate what type of ownership these people have intended for the account to be owned as. Now, we also know from legislative histories, and we provided this also in our brief, in 2019, the legislature embarked on some proposed legislation that it would have been as clear as a bell that they were changing the common law. This was Senate Bill 1154 from 2019, and the legislative analysis that
I'm a little concerned with this, and it goes to the common law abrogation too. I mean, from a notice perspective, the people of Florida have the statute on the books. Are you suggesting then that in order to understand the statute and whether or not their bank account is in fact one that's a tenancy by the entirety, they would have to look to legislative history and compare it to previously passed statutes, and then see, well, maybe this one was clear, but this one's not clear. And so this extra requirement that's not in the statute is in fact in the statute because of common law and because of this previously passed statute. I mean, now we're going like very far afield of what Floridians expect when they read a statute.
While it may not be as clear as some would like to discern from the statute, there's a lot of things in our society that stem from the old common law. And although it may not have been codified in statute, we are still, as Floridians, expected to know the law. And the ignorance of that law is not really a defense to anything. I think there's plenary of authority on that topic. And so to not know what, not just what the statutes say.
So you see the common law tenancy by entirety as touching a completely different subject than the statute. It's not a matter of statutory interpretation in your mind. It's like there is this separate law that applies to these accounts. A statute, isn't it?
Well, it's not a separate law. It's the common law. So I would think that it has, existed for, ages and ages and ages. And here, there is a little bit as to statutory interpretation.
In Florida, I mean, we have whatever it is, 1.02, that it adopts the common laws of July 2nd, 1776. That's essentially a statute. And so the legislature can amend that. Or they can create statutes that abrogate it, which is the language that we use. And so that's what I'm trying to understand. Do you see this as do you see this statute as touching the issue at all? Or do you see it as completely separate?
Well, and there is a portion of this that would be an issue of statutory interpretation. And this court has set forth the test for when the legislature through statute wishes to abrogate the common law. And we provide the authority in our brief that it's a two-pronged test that if a statute unequivocally states it's changing the common law, or that the statute is so opposed to the common law that the two cannot coexist. And in this situation, neither of those prongs have been met. The amendment to 655-79 doesn't mention that it's changing the common law. In fact, it uses the word made, which, as you know, the base definition of that term, which we take from Webster, we take from Black's, is a singular point in time when something is created. You know, when you make something, you're bringing it or causing it to exist. And so we're not.
What word do you use for making an account? Technical term that the public would be more.
Well, if you're talking about, let's say, you know, myself and my brother, so we're not talking about a situation of tenants by the entireties where I want to add, you know, somebody not my spouse to an account. Well, that would be an amendment to a bank account. I think, in fact, the banks, the forms you fill out, it's called an amendment or an amended signature card or some sort of subsequent designation or a change of designation. I'm sorry?
What about in the case of spouses?
Well, in case of spouses, this is where now we have the common law rules that would still apply.
But is there a different word that would apply to somebody who opens an account that gets married and then adds their spouse's name to the account?
Well, and the legislature could have used such language. In fact, in the proposed legislation from 2019, the proposed statute that they were going or thinking of enacting, it had language in there that would have been very, very clear. There would have been no question about it had that legislation been enacted, but it hadn't. And at the time of that legislation in 2019, and we provided it in our briefs, the legislative analysis at the time included the legislature's understanding of the current state of the law, and in fact it provided a fact pattern substantially similar to what we're faced with here today, where you have a husband with a securities account adding his wife to that account, and that absent the proposed new statute, it would not be considered tenants by the entireties. So the legislature knew this in 2019, and they still chose not to change the statute or to completely abrogate the common law.
For clarity, and I apologize that I just to make sure I'm not confused about this. Under the traditional tenancy by the entireties rule, if this account had been opened by the husband, and then he adds his wife, if we just there's no statute, just applying the tenancy by the entireties, that wouldn't, adding the wife wouldn't consider that being an account made by the husband and wife?
That would not be a tenants by the entireties account. It would fail for want of the unities of time and title.
Okay. And so I guess, are you saying that the other side, for them to win, we would have to think that what the statute was doing was changing that rule from the common law, essentially as if the legislature had said, going forward, an account is going to be considered made when you add, you know, the name of your spouse to an account. I mean, is that one way? Because, I mean, part of what's going on here is like, well, what aspect of the common law is sort of being changed, or is any of the common law being changed? I mean, you want to read this in this kind of minimalistic way of, this is really just kind of, the only work that this statute is doing is when we're looking at a form and there's 8 boxes, including tenancy by the entireties, and nothing is checked, like, how are we supposed to read that, right? But they're saying that this kind of made a substantive change to the law, as if the legislature had said, you know, we don't care when the initial account was opened, we're going to deem an account made, a new account of husband and wife made when you add someone to the thing. Because if you change that rule, then you could still keep your same tenancy, basically you would kind of under the common law. If I just said, well, this is going to be deemed made at a certain time, then I just apply my rule, right?
Well,
my existing rule.
Well, if this court were to do that, then this court would sort of be changing the statutory language. The legislature used the word made, right, with the definition of that word.
Misinterpreting the word made.
In a manner of speaking,
right? And so
yes.
Really the argument comes back to what the common law is helping us do is understand what the meaning of the word made is. Because your argument is basically the statute just doesn't apply because this account, they're basing the account having been made when the name was added, and you're saying, no, it was made, quote unquote, made before.
Yeah, and we're
right?
using a more logical definition of the word made, where, again, we
Which
take it
is
straight from Black's and Webster.
You're saying as a matter of ordinary language, but it's also, that's the understanding of the word made that's more consistent with the common law tendency by the entireties rule, which is the subject matter of the statute.
Well, when we're talking about statutory interpretations here and statutory construction, here we have a plain and unambiguous word. The statute itself doesn't define the word made.
You've already heard from several of these justices that they don't consider that, because let's pretend there's no common law. It sounds like you're hearing from several of these people up here that they would consider the account made in the name of two people when you add the name.
That may be,
So
but that's not the definition of the term made when used in context of the statute. There is no, if the legislature wished for the term made as used in the statute to mean something else, then the statute would have to say so. But because the statute lacks any definition of that term, we have to use the plain and ordinary meaning of the word.
Okay, you can have 30 seconds to finish up.
Sorry.
No, I mean, we've been asking, it's not your fault. We've been asking a lot of questions.
Well, just to sum up, to conclude, as we provided in the briefs, the statutory language does not abrogate the common law. It fails this court's test as to when a statute does abrogate the common law. I think we have really touched and hit on the point as to the term made, and the plain definition of that word as it should be applied in the statute is when an account is created or somehow is caused to exist. There is substantial, highly persuasive authority stating that in line with 655-79 sub 1 as amended, that to create an account by the entireties, all 6 unities must still be present when the bank account is opened, not when a spouse is added. And we would pray that this court resolve the conflict by adopting the opinion of the 2nd District and quashing the opinion of Versace from, 4th District's opinion in Versace. Thank you.
Thank you very much.
If I may, I want to very briefly talk about legislative history and then get away from that, because I don't think that is the appropriate role. But the legislative history does not support the position of the respondents. It's actually quite the opposite. The legislative history specifically only states that and I'll quote what the legislative history is that it specifically says that it explains what the court did in Beal Bank. That's it. And then it also says that the purpose of this statute is going to make it more difficult for creditors to reach assets.
You would concede that we would have a different case if instead of saying made, the statute said opened, right?
Yes.
Okay, so one statutory choice available to the legislature would have been to say when a deposit is made or an account is opened.
That's correct.
And then there would have been, well, help me then reason through what would have happened to the common law, because I go back to where I was before about this disjunctive about deposit or account. So if it said deposit made or account opened, how would that affect the common law analysis?
Well, because deposits are made throughout the history of the account, then maybe then perhaps that would show that the legislature intended there to be a distinction between the effect of deposits and when an account was open, since you can make a deposit at any time. Okay. That would be a very difficult chore for a court to do, to have to look at each of the deposits that were made.
So instead, the legislative choice was to just say made, a verb that works with both a deposit and an account. And one result of that legislative choice, if I'm understanding your argument, is that then they're basically abrogating the unity of time. Or they're saying, I can have a tenancy by the entireties in a deposit, not just an account.
That's correct. Yeah. And I think and that interpretation makes sense, what the legislature was attempting to do. They were they only mentioned one unity, the unity of marriage, and they don't mention any of the other unities, and they know what the unities are. And I want to go briefly to the 2019 law that did not become law, but what happened there was that was not an attempt to apply it to bank accounts. That was an attempt to apply it to all personal property. It was pushed by the Real Property Probate and Trust Law section, and the article that they wrote in connection with this, they said, quote, presumably, referring to the 2008 amendment, last sentence of 879.55, quote, presumably there is no longer a requirement to establish the unities in the case of bank accounts. The effect of the 2008 amendment to FS 655.79 does, however, create significant differences in the treatment of bank accounts as opposed to other personality. That was the purpose of the change in the law in 2019 that did not occur. So again, I don't think it's appropriate to consider the legislative history, particularly legislative history of a bill that didn't pass.
Do you agree, though, that the common law is relevant to our understanding of what made in the name of the husband and wife in this context means?
I actually don't think so, because I think the first thing to go to is the text. And if you but that does not help, because obviously the text, when you quote unquote go to the text and you're talking about something that's been governed by the common law for forever, then going to the text equals just, I'm asking you, going to the common, to say that going to the text means going to the dictionary or going to the corpus linguistics database or going to my gut intuition or going to the common law, those are all sort of substantive choices that you have to make at the beginning. So it's not an inherent thing. Except that the legislature knows what the common law is. Okay. They know what did the common law tell them about what made means? It doesn't say anything about that. The common law has 6 unities. In the context of tenancy by the entirety. It doesn't say anything about that. It says there are 6 unities that are required for a tenancy by entirety. And those 6 unities must be present. And what the legislature did, knowing what those 6 unities are, only included one of them, the unity of marriage. And knowing that, they could have made clear, and they could have said at the time a deposit is made or an account is open, they could have very specifically said that the unity that the unity of time is still present. They could have said that. Yeah, I don't know. But they made it very clear. It seems like a tough case, and it seems like the more one looks for sort of a conscious desire to change the sort of the common law background on tenancy by the entireties, I think the less evident that it is. If you think you're just kind of writing on a blank slate, it seems like a stronger thing. But if I were a legislator and I was thinking like, oh, there's all the 6 unities and I want to reduce it to 1 or whatever, I probably would have written this in a different way. I would say, notwithstanding X, Y, and Z, it'll be considered a tenancy by the entirety if you do whatever. You know what I'm saying? That's the way, if you're thinking in sort of an intentionalist kind of way. Yeah, and Chief Justice, I understand what you're saying, but the legislature knew what the common law unities were, and they wrote a statute that was repugnant to those 6 common law unities. And if they thought that any of those unities should still be present, they could have put that. They could have put that in here. If made is when the account is open, then they're not. Then it's not repugnant necessarily. Right? But it doesn't say made when the account is open, and it also says any deposit made, which is made throughout the history of the account. And again, going back to the nostrator ossosis doctrine, those words have meaning, and they have to have meaning. And the Missouri statute, which only says any deposit made shall be considered, in the name of a husband and wife, shall be considered tenancy by entirety. The court determines under those, with that, only that language, that is a tenancy by entirety account.
And again, Judge Kelly kind of used this language to cut in a different direction, but we know that the legislatures thought about the opening of an account, right?
Yes, they use that.
That's right there. It's tied to, in the first sentence, it's tied to opening or maintenance, but they've had that concept of opening. But they do not choose to use the concept of opening when they talk about this account made in the name of two persons.
I mean, that's partly because they're trying to use one word to cover both deposit and the account. I mean, arguably you could say the made refers back to the opening, but I mean, it's a tough, I think, it's a tough.
Yeah, and again, I think that this is to get back to Justice Sasso's point, that the public has a right to rely on what is seemingly
that doesn't
the clear
get you
language
anywhere,
of the statute.
though, because the public, essentially, you can't, reliance only makes sense in the context of understanding what the sort of rules of the game are. And if, it's like, how informed about law does the person need to be? Do they have to know that the changes to the common law need to be clear and they read it that way? Do they need to know that I'm supposed to be like a fourth grader who just can read English and that's what the law means? I mean, so the notice thing, the notice could completely cut either way, depending on sort of what your baseline knowledge is going into it when you open the book.
Yeah, and it's a little bit different because you're going into a bank and you're dealing with bank officers that are opening these accounts all the time.
Yeah, who know the common law. Probably.
No, who to the opposite know the statute, and because otherwise, why would they let them open an account where they mark in two different places that it's a joint tenancy by entirety account? Because they believed the statute meant what it said. Anyway, I apologize. I think I'm way over. Thank you.
Thank you very much. We appreciate it.
All rise.